out of Western Michigan earlier today. Andell Brown is a criminal defense attorney in Miami, Florida. He remains on the line with us now. Andell, a lot to unpack there. The headline was this, a couple of headlines here. First of all, we talked about this a little bit earlier, but the defendant blows a kiss, presumably towards the victim's family sitting in the gallery. It was bizarre. They reacted very harshly to it.
It was disgusting, Aaron. That's what it was. It was disgusting that these people are grieving. They've lost a family member they can never get back. And instead of showing this family some respect, he chooses to blow a kiss mockingly and in derision of their pain.
You know, it shocks me, but then I take a look at what this guy was accused of doing. You've got the Rebecca Blech murder. She was out jogging. She winds up dead. Her her earbuds, I think some stereo, equipment that people would wear when they're out jogging are basically the sign of where she was attacked. He also faces charges in the Jessica Herringa case. That's going to trial coming up in March of this coming year.
If these allegations prove to be true, then we're dealing with someone who seems to be devoid of feeling and compassion for, or even value for human life.
Exactly. He's specifically going around targeting people. They catch him after he tries to abduct a third person off the side of the road. And look, I got to give it to the local police department. They did some thorough investigation in trying to get this guy. It winds up with a third person being abducted off the side of the road. She gets away, says that his gun jams, and that were it not for the jammed gun, we probably, at least in the state's theory of things, would be looking at a third murder victim here. But she gets away. She goes to a nearby house just absolutely in pieces, in shambles. Right. And the testimony at the Rebecca Blech trial included all of these accounts, that person who escaped, just the sound of fear in her voice and the way that people described her, just awful. And so if you look at the chain of events here, you've got Rebecca Blech, you've got Jessica Herringa, you've got this third person. Not surprisingly, we then see that kind of conduct in the courtroom.
Right. It is not a surprise if you think about the type of person that would hunt down human beings as if they're some type of prey and take no thought as to how people will be affected. But it's still sickening to see, because I think about those families. I think about what they're feeling. I think about the courage it takes to stand up in that courtroom full of people and cameras and tell the court how you've been affected by this tragedy. And in the midst of that, he chooses to mock this family. It's absolutely disgusting. And I really feel sorry for those people that had to witness it.
Well, look, we can sit here and feel more comfortable in the verdict and the sentence, though, given that we've now observed some disgusting behavior for ourselves. Let's talk a little bit more broadly about this, though. We were here for sentencing for the Rebecca Blech case. We had victim impact statements. I wanted to talk more generally about them while we have some time here. What's the purpose of the victim impact statement?
Well, I think the purpose of the victim impact statement is the overall goal of the criminal justice system, that is justice. And I think in order for a court to get a full perspective of how a crime has affected the community, they have to talk to the people that have been directly affected, the victims. I think courts take them into consideration and they weigh them heavily when they're making their decisions about what the sentence should be. Of course, they look at other factors. They look at any prior criminal history. They look at the nature of the crime, whether it's sophisticated, whether it seems to be premeditated, whether it's particularly egregious. But I think the victim impact statement is one of the things that the court definitely considers.
Yeah, that was my next question, is do judges actually consider them, or do judges walk out there saying, hey, look, I've sat through this entire trial. I've sat through the pre-hearing. I've got, in most states, if not all states, a post-sentence investigation report. I've got recommendations. And in some cases, I've got my hands tied by the legislature. They say this is what I have to sentence this guy with. Do judges take them into consideration? Your opinion is yes.
I think they take them into consideration. How much weight they give them, I think obviously it's going to vary by the judge and the jurisdiction. Some judges in their sentencing, before the victims have even spoken, they've already considered the devastating impact to a victim in a case, depending on what happened. Or some judges, they may look at it and say, okay, we understand the nature of this crime, we understand what happened, but we may not fully appreciate what has happened until they hear from the victims directly.
Yes, and we've had other cases that we've covered here at Law and Crime, such as the Michelle Carter case, where we had some statements made to the court in a sentencing hearing there, and the judge actually got up and paused the proceedings and went back into chambers, and we were sitting around the table here, that is Dan Abrams and myself. I think Caroline Polisi was also here, and we said, wait a minute, is the judge actually potentially going to change the sentence now? And of course, while we're on the air, I dug into
Newsflash, judges are human.
Yeah, right. Okay. And then one of the things I dug into is in Massachusetts, it was mandatory. It said the judge shall consider. That means must consider victim impact statements. So I made the comment then, hey, look, this judge is being really clear that he's going by the book here. He's going to consider them because it says he has to. So he took 15 minutes, he took a timeout, came back and delivered a sentence. Not all statutes have that shall. They don't have the mandatory requirement in them. But look, you know, it raises a sort of a age-old question that the Supreme Court has struggled with over the last 30 or so years, if I'm remembering my jurisprudence properly, whereas are trials about victims or are they about defendants? And just because a defendant, if you believe their guilt, and I realize I'm flipping a presumption here, but you know, should they face a harsher penalty if their intended victim is somebody everybody loves, or somebody, you know, and I'm just speaking hypothetically here, who recently moves to town who nobody knows? You know, should that really play into the way that we consider justice?
Right, and I don't think it should. And as with most things in a criminal proceeding, it is overwhelmingly about the defendant. The defendant has the rights, the defendant has the protections, and rightfully so, because something very precious is on the line, and that's freedom. However, I think that what you stated as far as someone who just moved into town versus someone who everyone loves, I don't think that should make a difference. That would be partiality. I think each case should be looked at on a case-by-case basis, and I think it's fair to look at the effect that the actions of the defendant had on the victims. Whether it was catastrophic or not should have some bearing.
I would agree with that. That sounds completely fair to me. And look, I mean, people who suffer through these crimes are scarred. They struggle with them. Some people struggle with them differently. If there's one thing that life has taught me as a journalist communicating with victims' families for several decades here, it's that it's impossible to predict exactly how someone is going to react, how they're going to, you know, some of the best reformers in our system are people who have been affected by crimes. Some take up the torch of reform. Some turn back to their own families. Some never want to talk about what happened at all, ever. And some are adamant that, you know, they're blowing up my phone as a journalist saying, look, I've got something to say about this. Right. And you know, everyone reacts a little bit differently. But oftentimes these victim impact statements are a catharsis for those who really feel as though that they need to unburden their souls with something articulate about what happened, how they've been affected. There's an old quote I'm remembering, and I'm probably misquoting it, but basically that there's no greater burden than a story untold inside yourself, and that oftentimes is something that victims' families need to unburden as part of their own healing, and these statements play into that.
Yeah, I think it's a great part of the search or the quest for justice, where people that have been affected get an opportunity to speak. Whether or not it changes what the sentence is, we can never be sure because we can't peer into the minds of a judge, but I think they should be given the opportunity to speak and to be heard.
I agree. So we've potentially got a chance to see this defendant in front of a jury again coming up in March if the schedule holds, because that's the Jessica Herring case. That's the accusation that as part of this crime spree he was on, that he murdered a gas station attendant. And, you know, look, we just had him tried, we just had him sentenced. why try him a second time? I'm asking a rhetorical question, but I'm
Right.
curious to hear your answer, which I am certain is going to be articulate.
Thank you, Aaron. I learned from the best watching you. But I think we have to look at the fact that if you're looking from the prosecution side to make sure this person never is able to walk the streets and do this to anyone else again, you can't just hang your hat on one conviction. If you have the possibility of another conviction, you have to go and get it. Cases get overturned on appeal. Those things happen. He could get some relief from the appeals court that could cause that conviction to go away. So you don't want to leave any stone unturned, especially when it comes to a person who has shown that they are willing to go out and do almost anything to anyone with no remorse.
Exactly. That's exactly why we need to have a second trial. So we're bracing ourselves for that. If the schedule holds, that's said to be occurring sometime in March. And look, this is another one of these rare cases where different states interpret the evidence rules a little bit differently, or they have different evidence rules altogether. In some states, we wouldn't have seen all of the evidence of a crime spree or similar crimes getting thrown into one particular trial, but we saw that here in Michigan. We saw information about Jessica Herring. We saw the third victim, the person who escaped, all come into the Rebecca Bletch case. And that's because one way you can get it in, and again, some states are more harsh about this than others, is to bring evidence of a common plan or scheme and say this crime looks so much like the other ones that we're convinced that this guy did all of them, and then it all comes in together. Other states just say, wait a minute, we can't just pile on evidence to make it look like somebody's guilty by throwing a million accusations at them and hope that they all stick.
Yeah, I think many judges that I've come across are very careful about that, because on appeal, you want to make sure that your case by itself holds water and it's not just a collection of all of these other things and unrelated issues. You want to make sure it's relevant, it's on point, and it's admissible in the case at hand.
Yeah, so let's switch away now from the Jeffrey Willis case, because that one, again, there was a sentence, life in prison for the murder of Rebecca Bletch. We saw the conviction here on Law and Crime a while ago. We got sentencing. We've got another trial for the same defendant coming up in March. We'll keep an ear and an eye on that. But we're also talking about Curtis Reeves again, and this is a case that dates back to earlier this year, a hearing as to whether or not this particular defendant was going to be able to use the stand your ground law in order to defend himself on accusations that he basically shot and killed a guy in a theater. Now, the defendant claims that he had to defend himself, that he was in fear that he himself was going to be harmed. The judge didn't buy it and just said, look, this is a bunch of hooey, you can't throw this defense up. But an appeals court's taken a look at it, and it caused a flurry of re-examination of this case. And I was trying to figure out earlier today exactly what was going on with this thing, because I'm like, wait a minute, we've got an appeals court decision. Did something get overturned? It's not quite that strong yet. And you dug into it a little bit more than I did, because you're licensed in Florida, so you have all the secret portals that I don't have to try to figure out what's going on here. So what's going on with Curtis Reeves?
Well, when I looked into it, Aaron, I actually looked at the writ of prohibition that was filed by his defense team, and I looked at the docket on the Second Court of Appeals, and it appears that they're simply saying this writ of prohibition has been filed. Attorney General, you have 10 days to file a response to it. That appears to be a very routine matter. When something is filed, the other side has an opportunity to respond. However, looking at the motion that was filed, it brings up some very, very salient issues in this case. And it's kind of a relitigating of their case, a relitigating of their stand your ground motion. They're talking about Curtis Reeves, his physical condition compared to Mr. Olson, Chad Olson, and what Chad Olson was younger, he was stronger, he was bigger. It's what I would like to call the eggshell defendant kind of defense, where they're saying, oh, I'm so small, I'm so frail, if I get into a physical altercation, I'm likely at a great risk for bodily harm, which is why I had to use deadly force. I had no choice. That's what they're arguing. They're arguing the judge got it wrong when it came to whether or not Chad Olson hit Curtis Reeves in the face with his cell phone, and whether or not he made up that story afterwards to defend himself or to keep himself from getting in trouble.
Yeah, I mean, we're importing that eggshell plaintiff rule in from personal injury law because, of course, the personal injury rule that we all learn in law school is, look, if you're out there and you do something negligent and all of a sudden somebody winds up with 50 broken bones, the phrase is you have to take your plaintiff as you find him. If you do something negligent and it causes a substantial degree of harm to somebody, then you're still on the hook for it. You can't turn around and say, oh, I didn't think it was going to hurt him that much. You have to take the injuries that happen as they are. Trying to import that a little bit here into the criminal realm is interesting. But let's back up for a little bit here about this. For those who don't know the term Florida writ of prohibition, what was it that Curtis Reeves' attorneys actually filed? What is a writ of prohibition?
Well, they're filing to the appeals court saying that the judge should be prohibited from entering the order denying his stand your ground motion. They're saying that the judge got the facts wrong, the judge got the law wrong, and it should be overturned, reviewed de novo, or as if the appeals court was actually the one hearing the evidence. That's what they're asking for.
And you said that this was very articulate. It was a well-drafted motion. In other words, this isn't just some garbage that they're throwing up at the appeals court and hoping it sticks. You think that this has got some teeth to it?
I think it does, just from reading through it, the level of detail that they went through in making sure all of the facts were there, explaining the different experts, their testimony, their qualifications, and how they arrived at their conclusions, and tying it all together. All in all, the document was about 80 pages.
Wow. It's a good-sized motion. Now, oftentimes, when I was clerking for a trial judge, he impressed on me that, look, it's the defendant who's at jeopardy here. The state has the burden. The judge impressed upon me, and I don't know, perhaps the judge has impressed this upon you at some point as well, that, look, we kind of want to let defendants defend themselves in a way that they see fit. In other words, give the defendant a pretty long leash under the law to present a defense to a jury and then let the jury sort it out. Now, obviously, you got to do that within the parameters of what's right and what's wrong under the law. But that's the way the judge that I worked for and who helped me understand this taught me to look at some of these issues if we were to encapsulate everything with a big, huge, broad brush. Now, do you think that this guy should be able to present this defense ultimately, that just shutting it down at the judicial level doesn't let a jury really get into it and say, is this reasonable or is this not? Because usually that's the job of the jury.
It is, and that's not what's happening here at all, because the judge is simply saying that I'm not going to decide that you have immunity from prosecution. The jury can still consider stand your ground and the elements of it as a defense on their own. The judge, however, said, I'm not going to grant this motion and dismiss this case and prevent the state from prosecuting you. I'm not convinced that you've met your burden. One of the things that has changed in Florida recently is the standard, well, not the standard, but the burden in stand your ground motions. Previously, the defendant, and Mr. Reeves' case falls under this, they had to prove by a preponderance of evidence that they were in danger of great bodily harm or death. Now, in the state of Florida, the prosecution has to prove, once the defense says, we believe we were in danger, now the prosecution has to overcome that by the preponderance of the evidence, and that's a difference here.
Okay, so it changes the procedural posture of things. I want to dip back in and listen to some of the testimony in a hearing on this matter that happened earlier this year. It was a lengthy hearing. Let's listen to the defendant himself. Let's listen to him explain what he says happened, and we'll keep it in mind that this thing is getting reviewed right now by an appeals court.
All right. So you and your wife go to the matinee theater to see Lone Survivor that day?
Yes, sir.
You get there about close to somewhere around before the movie starting?
Around 1 o'clock, yes, sir.
Around 1 o'clock. Okay. And what do you do when you go in?
Well, we buy our tickets, we go inside, we stand around the concession area for a little while, then we were going to meet our son. He was going to meet us there. He he was running a little bit late, so we bought a bag of popcorn and a cold drink and went inside the theater.
And where exactly did you sit in that theater?
Well, when we came in, there was a lot of folks there. Since there was 3 of us, everybody on the matinees liked to put a couple seats between them and other people. They kind of spread out. So we found 5 seats together on the very last row at the very top of the stairs, about in the middle of the theater.
At the time that you went in, what was showing on the theater screen?
They had some commercials, some advertisements, that sort of stuff. Yeah.
And did there come a point in time where you were seated there and an announcement came on the theater screen concerning cell phones?
I think I think it's like for the snack bar comes on. I think the theater, the lights go down, and I may be off a little bit on exactly when the lights go down, but there's a snack bar feature, and then following that is I guess it's a courtesy announcement to turn your cell phones off. Yes, sir.
Okay. And had your cell phone been turned off by this time?
Yes, sir.
And after this announcement to turn off your cell phones, what happens?
As the previews came on, I noticed a gentleman that was sitting in front of my wife had his cell phone out, and it was kind of shining in my face.
The light from the cell phone was shining in your face?
Yes, sir.
Were the previews on at this point in time?
I believe it was. Yes, it was a previews. Yes.
And were you trying to watch the previews?
Yes, sir.
And were the previews of interest to you?
We always like to see what the previews are, so we know if we want to go see the movie or not. So yeah, we always watch that.
Do you and your wife frequent the movies often?
When we want to go and relax, yeah. If there's something showing that we want to see, we do.
And so as you were watching the previews and the light was shining on your face, tell the court what you did.
After, I don't know, 15, 20, 30 seconds, I leaned over to the gentleman and I said, and my voice was low, and I said, "Sir, can I get you to put your cell phone away?"
And was there a response to that?
The response was, F off, or get the F out of my face.
Did you respond to that statement by this individual?
I got away from him. Oh, I didn't say anything, no, sir.
That was the extent of your
That was it. No, sir. I got back in my seat.
You got back in your seat. Now what did you do?
Well, I watched his wife reach over. I assume, well, I now know that it was his wife. She reached over, and it looks like she's trying to talk to him. And so I just kind of stayed back and stayed out of the way to see what would happen.
Did you expect him at that point in time to, at the very least, turn off his phone?
That would be the expectation, yes.
So how long were you now seated back, waiting for him to comply with the announcement that had been made by the Cobb Theater?
Well, well, he had seen that, and then I had probably waited, I don't know, 15, 20, 30 seconds before I said anything to him, because it looked like he was busy on it. So after I spoke with him, then I saw him and his wife having some interaction. She looked like she was trying to talk to him. She had put her arm over on him, and then they kind of settled down, and the light was there again.
And what did you do again?
I was thinking that he would put it away. He'd been, I had requested it, and so I waited probably, I don't know, maybe close to a minute, half a minute, 3/4 of a minute, something like that, and it was still there.
So let's talk about this. I want to make sure that the court is clear on the sequence.
Right.
20, 30 seconds, you're trying to watch the previews, the lights are on, your face, the light of the cell phone.
Yes, sir.
You lean over.
Yes, sir.
And say, "Sir, could you put your phone away?" The announcement came off to turn your cell phones on.
Right.
Your Honor, I'm going to object to this summing up.
Yeah.
I will. Let me get I'm just getting the sequence.
Well, the sequence, we've
I'm
all
not gonna- I'm
heard,
not
we're
gonna
all
read it.
taking notes.
All right, well, let's not, I heard it the first time.
Okay.
We don't need everything summed up, all
Okay.
right? And no leading.
After you made that first request.
Yes, sir.
You indicated that you were back. How long did you wait before you had any other contact with him after that first request?
I'm going to say at least a half a minute or maybe longer.
What were you waiting for?
My thought was that he would comply. His wife had spoken with him. I felt like that he would ultimately comply, so I didn't push the issue. I just waited to see what was going to happen.
So now what happens?
The cell phone is still there, and so I lean over and I'm not belligerent. I'm quiet. I don't need to wake up the whole theater, and I tell him that you leave me no alternative other than to notify the theater management, and
What, does he respond to that?
almost immediately,
What did he say?
I don't give the F what you do.
And so what did you do now?
Well, I sat back and I thought he would put it away then, and it was still there. So I get up to leave, and as I'm leaving, my wife says, "Why don't we just move?" And I said, "I'll be right back." And I gave her my popcorn box that I was holding. We had split the popcorn. She had a bag, and I had the bag. So I gave her my bag, and I walked down the aisle and went down to the manager's office.
What was your intent to go down to the manager?
Just to get this guy to put his phone away, just so I could watch the movie or watch the previews.
And so did you go to the managers?
Yes, sir, I did.
And was the manager busy speaking to someone else beforehand?
As I walked up to where the manager was, there was a lady standing there talking with him. So I just waited until he had completed dealing with her.
And after she finished speaking with the manager, did you have a conversation with the manager?
Yes, sir, I did.
And what did you tell management?
I told him that I said I'm kind of embarrassed to be here. I said I got a guy that's sitting in front of me, that's sitting in front of my wife, that I had asked politely to turn his cell phone off, and he basically told me to F off, and so I said, he doesn't seem to have the right attitude for me to try to talk to him again. I'd appreciate it if you'd help me out here.
Okay. And then where do you go?
He says he'd take care of it, so I turn around and come back in the theater.
Is that something that you would expect the patrons at Busch Gardens to do as well?
I think the plan would be to go to management. That's what we trained for 12 years, that our employees, if they had an encounter and it didn't go well at the first time, that you would go find a manager. Yeah, that's how we handled it.
And so now you went back to sit down?
Yes, sir.
And did you?
Yes, sir, I did.
Did you go up the stairs?
Went back up the stairs, back down the row, and when I got to my seat, I took my bag of popcorn from the wife and turned around and sat down.
Before sitting down, did you have any conversations with this gentleman again?
I said one more thing to him, yes, sir.
And what did you say?
As I'm walking down the aisle, he looked at me. I guess you could say it was a stare, perhaps. So as I went past, as a goodwill gesture, I told him that I didn't see his phone at that time, so I said, I see you're not on your phone. Sorry I involved theater management. It may not have been those exact words, but that's what it was.
Okay. And then what did you do?
I took my popcorn bag and sat down next to my wife.
You took your popcorn bag from your wife and sat down?
Yes, sir.
Now what happens?
I hadn't been sat down any time at all, and I see that he and his wife are are now interacting again. And she's got both hands on him, on his left arm this time. And he jumps up. I say jumped up. He stands up very quickly. And he swings around and faces my wife, where my wife is sitting. He's directly in front of her. He's just before or just as he stood up, I heard something about theater manager, but I think it was in a conversation with his wife. It was very loud, so I think he was just being loud.
So now what happened?
His motion and swinging around got my eye. He's right off to my right here, caught my eye almost immediately. When I looked up, he was coming over the seat at me, across the front of where my wife was. And he had, I saw just a snapshot of something dark in his hand. Almost immediately I saw what I perceived to be a glow from a screen right in front of my face, and I was hit in the face.
What happened to you as you're hit in the face? You know where you were hit, do you think?
Over my left eye, I think, in this area. It must have hit my glasses because it knocked my glasses. I think it knocked my glasses off at that point.
Completely off?
Just off the side of my head. They were still in place on the right side, but this arm on the left side was down on my cheek. I didn't realize that immediately. But in a couple seconds.
And why didn't you realize that immediately?
Well, I knew that as soon as I got hit, that everything was blurry, which I have 20/20 vision with my glasses, so I didn't immediately associate the fact that I didn't have my glasses on until a little later in the event.
Your glasses on or your glasses on?
On my head, but off askew, I guess, on my face.
Okay, and what are you trying to do at this point?
I was kind of dazed. I was disoriented. I was trying to get my thought processes back together as to what happened because it was so unexpected until, it's just something that you would not expect to happen in a theater.
Was there any verbalization whatsoever while this process was taking place?
I heard the I heard the brief. I heard his voice when he was talking with his wife. I didn't ever hear her voice. It was loud, but he was facing the other way. After I got hit, then he was facing me. He was very loud at that point.
And what was he saying?
A lot of sentences with the F word. I'm going to kick your F and ass. I'm going to F you. If it was any of your effing business, I was texting my effing daughter. And I heard those in a sequence that may not be the ones that I repeated, but I heard them all at some point at that time period.
What happens next?
Well, my first effort at anything was to try to get out of my seat, to try to stand up.
So how did you attempt to do that?
Well, I had a bag of popcorn in my left hand, and I normally, because of some issues over the years, I usually push off with both hands.
Push off where?
Push off the seat, off the hands here. One hand was occupied with the bag. I tried to stand up by just leaning forward. Then I realized that was not a good idea.
Why was that not a good idea?
Well, the guy that just hit me was right there. You try to get away from him, not closer to him.
And so what did you do once you realized that trying to get up was not a good idea?
Then I got back in my seat as far as I could to increase the distance between us. And that's when I kind of became aware that his wife was trying to hold on to him.
When you're saying you were trying to create some distance, you could show the court, I think she could probably see it if she stands up. Show the court what you were trying to do in your seat to create that distance.
Well, the seats have a little bit of spring to the back of them. So what I was trying to do is get as far back in my seat as I could. And then I remembered that I had a 5 or 6 foot wall behind me, so I was, there was not but too many places to go. At that point, I felt like I wanted to get him away from my wife and then further increase the distance. So I leaned as far to my left as I could in my seat, and I didn't want to bump his seat, so my right leg went out to the right side down the aisle where my wife was to try to keep him away from me. Right.
During this entire time, where was your focus?
On him.
And why was your focus on him?
Well, you find yourself in that kind of an encounter. There's an old saying, you lose your focus, you lose your life.
And so you weren't about to get your focus off of him?
Not a chance.
What did you see happening next?
I saw he was continuing to speak loudly, very loud. He was, his wife was trying to hold on to him. And as I'm in that position that I just demonstrated for you, I realize I'm trapped.
What do you mean by trapped?
I can't get up, I can't get out. He's right in front of me, and he's trying to come over the chairs. Again.
And so what do you do?
I think at that point, at some point in between when I was first struck in that incident right there, I realized that I was in a life or death struggle. That all of a sudden he was no longer a loudmouth, that he was now a very definite threat. At some point in time, because of the position that I was in, I reached for my pistol.
Describe to the court during this period of time as to how he was trying to come at you again.
He had moved a little bit over to his right, which would have been a little bit closer to, I think, his wife. He was kind of in that little crack area, I guess you might say, in between the two seats. She had been trying to hold on to him, and it looked like that at that point he suddenly either got away from her or he found a stable position, either on his seat or on the floor or something. He was suddenly right in front of me, higher up off of the seat than I was, looking down at me, and he was yelling some of the same things that I mentioned earlier.
Was he continuing to move in your direction?
He was reaching for me.
And so what did you have to do as he was reaching for you?
When I realized that he had gotten much closer and that he was, I guess there's a thing where you see somebody getting ready to set up to punch you. And he was getting ready to punch me, and I perceived that at some point, and that's when the pistol came out.
And what did you do with that pistol?
I shot him.
Did you want to shoot him?
Absolutely not.
So why did you shoot him?
Well, at that point, it was his life or mine.
Did you feel he was going to hurt you?
We are watching testimony from a defendant in a hearing we covered earlier this year on the Law and Crime Network, back when we were still Law News and before we really had a fully functioning network. But the reason we're looking at it is because that defendant, who tried to claim a stand your ground defense on charges that he shot and killed someone, during an altercation in a movie theater. That defendant is now asking an appeals court to get in the middle of his defense because the trial judge said, look, this doesn't make any sense based on the evidence that we have, based on the security camera footage, and I'm not going to let you move forward with that defense in that fashion. So we now have an appeals court basically taking a look at whether or not the judge should have shut the case down based on the stand your ground defense and basically let the defendant walk, or whether or not the judge was correct in saying, look, let's submit it to the jury. That's where that case stands now. That's why we were reviewing that defendant's testimony again. Andell Brown remains on the line with me. And Andell, I wanted to talk a little bit about the next case that we're planning to cover. It's an Iowa case involving a defendant named Larry Whaley. And we're right now in the middle of jury selection in that case. We were hoping it would wrap up this afternoon, but it will not. They're going to push into a second day with jury selection. As we understand it, we are hoping to get opening statements sometime tomorrow. But this is a case where a guy basically opened fire on somebody who knocked on his door, as I understand it.
Right. From what I can tell, he shot through the door and hit Samantha Teeter, who was out there in the hallway, and died from her injuries.
And we don't know a lot else beyond that. This has been a case, it's in a small area. We're talking northeastern Iowa. Not a lot of attention paid to it, but has the defendant given any excuse for why he did this? This case can be described as somewhat bizarre from the way the defendant has behaved. He sent several sometimes incoherent letters to the judge and other people. What I can divine so far from what I've seen is that he's saying it was an accident. I thought they were trying to break in. It seems to be that there were some people, whether real or imaginary, I don't know at this point in time, who he believes were trying to break in at some point. And he thought she was one of those people. And it appears he fired his gun through the door. But as you said, Aaron, there's a lot of information we still don't know. Yeah, it's certainly a bizarre situation, but we're hearing more and more of these cases. Perhaps it's just because we're paying more attention as a society to them, or perhaps we're just become that distrustful of people who might be knocking on our doors. Mm-hmm. That you get more and more of these cases where people are just opening fire through the front doors of their homes, their apartments, what have you, and then someone is laying dead outside. Right. What happened to looking through the peephole?
That's a great question, and I don't know whether or not he looked through the peephole before he fired their shots. I don't know what he saw. I haven't heard that testimony. But what I find interesting in this case is that initially they charged him with first-degree murder, and now they're proceeding under second-degree murder in Iowa. And Iowa's definition is a little bit different than ours. Like here we have certain criteria for second-degree murder, depraved, et cetera, et cetera. There, it's simply almost anything that's not first-degree murder where someone died goes under the second-degree statute. So something must have changed for them to move it from an intentional, he premeditated killing to now saying it's under a little different category.
Well, that would make sense based on the version of the story that we've gotten thus far, because usually juries, when they hear that a crime requires premeditation, they usually aren't comfortable with split-second premeditation, although legally, theoretically, in most states, they can do that. Usually when juries want to go for that top premeditated homicide charge, they want to have evidence of premeditation other than just speculating as to the defendant's mental state. They want to see evidence of a plan. They want to see a document. They want to see a text. They want to see some lengthy history of a spat between the defendant and the victim. And I think in Florida, well, you guys don't require that quite that way in Florida. And I'm thinking out loud, but doesn't your second degree charge require some relationship between the victim and the defendant?
Yes, it does. That's a recent legal development where they're saying, like, you can't develop the animus necessary in an instant. There has to be some type of prior relationship between the two parties to fit the second-degree murder statute.
Yeah, and so given that change in Florida, and I realize we're talking about Iowa now with the Larry Whaley case, but a lot of times juries just don't want to go there with that top charge without having a relationship, some kind of a history of trouble, something where a defendant could, in the mind of the jury, be building up some kind of intent and then acting on it. So if that doesn't exist in this case, I can see why a prosecutor would want to bump it back down.
I totally agree. I think it was a great decision because initially when I looked at the case and I saw the charge, I'm like, they overcharged this case. They're going to lose credibility with the jury where they come in and saying we're going to prove something that it does not appear they have the evidence to support.
I just got a note about some of the jury questions here. In other words, in voir dire, we're talking to jurors about whether or not they can sit on this particular case in Iowa. Pretty standard questions here, Andell. Some of them involving, do they know local police officers there in Mason City, Iowa, where this is occurring? Do they understand that what they see on the TV show CSI does not equal an actual for real courtroom? These are pretty standard questions.
Absolutely, there are. In a case like this, you just kind of want to get to know the jurors to make sure that you identify any biases that they may have that won't allow them to rule fairly on the case in either direction.
Yeah, exactly. Now, I will give you a chance, Andell Brown, attorney, Miami, Florida. What is your all-time favorite voir dire question that you ask?
Oh, man, it really depends on the type of case, Aaron. A lot of times we like to ask, just because the defendant is sitting here, you see this person sitting here at the defense table, they're sitting here with their lawyer, who thinks they're guilty just because they're here? And I think that's a question that kind of touches on a lot of people that have the preconceived notion that you must have done something if you're here. And if we can draw those people out, it helps us take people off of the jury that won't give the defendant a fair shot.
That's a good way to ask it. If I'm trying a case someday, I will have to steal that if you don't mind, because
it's all yours.
Look, this is, well, it should be every defense attorney's, it would seem, because that's what they really need to ferret out, and I think that's an effective way to ask it. A lot of people put a lot of trust in the police in getting the right guy in this country. And look, I realize we're in a post-Ferguson, post-Black Lives Matter time where the police have been under an incredible amount of scrutiny. And look, I'm all for scrutiny. I'm a former journalist who's now got a law degree who's back in it. I think we should scrutinize things, but we want to scrutinize fairly, and we also need to understand the reason our justice system gives defendants a presumption of innocence going into a proceeding, and there's a good reason historically as to why the government has to have the high burden.
I think it is one of the features that makes American law what it is. If we're about liberty and justice for all, and we place such a high value on freedom in this country, our courts have to act like it. So I think it's very important that we have this, and we want to make sure that jurors, because most people don't deal with this sort of thing on a day-to-day basis. They're thinking about other things. So the presumption of innocence is the last thing on their mind. But you want to make sure that a juror understands the importance of, number one, their presence there, what they'll be doing, the role that they're going to play, and also the fact that the presumption of innocence and innocent until proven guilty is an important part of what America's all about.
Exactly. Couldn't have said it better myself. So we're going to continue to listen to some of the testimony in the Curtis Reeves case. Keep in mind, folks, Whaley, that's our next trial coming up here on Law and Crime. We were hoping to have opening statements today. Looks like jury selection is taking a little bit longer than perhaps even the court would have preferred. So we're hoping to be able to carry those for you tomorrow. In the meantime, let's switch back and listen to a little bit more testimony from the Curtis Reeves case earlier this year.
seated, thank you.
Thank you. Judge, I'm going to begin my cross by playing a video. It's marked as State's Exhibit number C for identification. It'll be item number 1AWS as identified by the by the Pasco County Sheriff's Office. On that particular exhibit, I will be playing file number 20140113131442. This will be the original export of the surveillance video from the GeoVision system, unaltered, unedited. It is the, quote, best evidence in this case. You've heard testimony about a USB key was handed over through Mr. Myers to Detective Smith because it was downloaded off-site by Eric Andrews. This is that thumb drive, and I will be playing a portion of the file number that I put on the record. It is also one of the items that by stipulation the chain of custody has been stipulated to, along with authenticity.
Authenticity.
Yes.
Love that word.
Tough to say after all those antihistamines, everything's dry. And because this is the original best evidence, I had someone with more savvy than I. We actually used a write blocker so that it could be downloaded onto my hard drive so that the computer would not go back and add anything to the exhibit. So I do have the exhibit here. I do have the write blocker. Like I said, someone knows how to use this. They did that for me. So I'm going to be playing it off my computer, but you will see up on the screen the file number that I placed on the record. But for safety purposes, I prefer not to keep putting this thumb drive in and out of the computer without someone who really knows how to use this write blocker.
Okay.
All right?
Yeah.
Okay. If I can find my glasses.
Yeah, right on.
Okay.
There we go. Could have been on my head, it would have been less embarrassing. Just a second. There we go. Now what I'm going to do, I'm going to back it up to the very first part where Mr. Escobar was discussing and Mr. Reese was discussing. There's a break in the recording, and it's the frame where Mr. Reeves indicated that Mr. Olson comes into the frame. And this is at 13:26:24. Mr. Reeves, what I'd like for you to do is watch the screen. This is the place where you indicated that you had a difficult situation with Mr. Olson. You can see in that particular frame, that is the frame you had a discussion with Mr. Escobar about, in your opinion, Mr. Olson was coming over the seat, right?
That's correct.
Mr. Reeves, you're going to have to speak up. I know it's been a long day, but we're going to have to get this on the record. Okay, sir?
I understand.
All right. So can we start over a little bit? Because I'm all dried up with antihistamines. You've been talking for the last 4 hours, so we're just going to have to suffer through it. All right? All right. Now, let me start over. This particular frame, this is where you had a discussion with Mr. Escobar about, and you told us that you perceived Mr. Olson coming over the seat, correct?
That is correct.
All right. And Mr. Escobar asked you about the white white area in the screen. You remember that?
I do.
All right. I want you to look over there. Do you see that?
I do.
And then he put on a second exhibit, I believe, and it was a loop. And we had the yellow circles and the red circles, remember that?
That's correct.
All right. Now, I believe you indicated that it is at this time you believe that you were hit by Mr. Olson with something.
I was hit by Mr. Olson with something.
All right. Now, what I'd like for you to do, just like Mr. Escobar did, I want you to watch and follow the white area on the screen. Now that is you uncrossing your legs, isn't it, so you can lean forward?
It's possible, yes, sir.
There you are with your legs crossed, because that's the way you were sitting in the theater. And this is you uncrossing your legs, correct?
I do not recall crossing my legs, but it is possible.
You indicated that it was at this point in time that the reason for the movement was that you wanted to stand up.
I got hit in the face.
You indicated that the movement here was that you wanted to stand up,
Judge,
correct?
I'm going to object. That was not the location where he said he wanted to stand up. Is when his actual body is moving. There you go.
I'm going to get Mr.
But you
Judge.
can't ask the question on another frame, Judge. That's the problem. If he wants to get to the frame that he wants to ask a question on, then get to the frame and then ask the question.
Go ahead.
Thank you. We had discussed that this is the location. We're going to change topics, but this is the location where you said that you believed that Mr. Olson was coming over the seat and you were hit with something, right?
That's correct.
All right, now we're going to go forward. I want you to watch the white mark. We're going to stop it there. You're beginning to lean forward, are you not?
That's correct.
All right. In order to lean forward, you're going to have to uncross your legs, are you not?
If they were crossed, yes, sir.
All right. Now, I believe you indicated it was at this point that you were going to stand up.
Yes, I moved forward in my seat, yes, sir, after getting struck. That's correct.
You leaned forward in your seat and you closed the distance between you and Mr. Olson, did you not?
Until I realized that's what I was doing, yes, sir.
All right. Because as we see from the frame, as we move it back, Mr. Olson is moving out of the frame as you're moving towards him, correct?
That's what the frame seems to look like, yes, sir.
All right. So he's backing up from you and you're moving towards him.
I'm moving towards him and his wife is pulling him back.
His wife is standing up, is that your testimony?
No, sir, she's in the seat next to him and she's trying to hang on to him.
And he was in the seat next to her, right?
That's correct.
And both of them were sitting down at that point.
He wasn't. He was kind of come over the seat.
All right. Your testimony is at this point he was trying to come over the seat?
That's
132625?
That's correct.
All right. And it's your testimony then that Miss Olson, seated in her seat, was trying to reach out to her husband that's 6'4" and trying to what?
Well, she had been holding on to him, trying to hold him back, I assume.
While seated in her seat?
Yes.
Okay. And what part of the body was she holding on to?
Well, when he first turned, she was holding on to his arms.
All right. And Mr. Olson is a very tall, lanky individual, is he not?
That's correct.
Now, I'm going to go forward because I know there's a...
Okay, folks, we're going to break out of that review of the Curtis Reeves hearing from earlier this year. Again, his attorneys have asked an appeals court to get in the middle of his case to once again try to press a so-called stand your ground defense. The appeals court has asked the Attorney General's office to respond back. We're keeping an eye on it, as we always do. We still have Andell Brown on the line from Miami, Florida. And Andell, we've been talking about the next case we're going to cover starting hopefully tomorrow here on Law and Crime. That's the Larry Whaley case out of Mason City, Iowa. One last question about that situation. It surprised me that a judge would start a murder trial this close to December 25th, Christmas Day. Usually the courts want to clear their docket and then pick things up at the first of the year. So now look, I will admit that for selfish reasons, it's great that we have a case to cover here at Law and Crime. But look, jurors have got to be trying to figure out whether or not they've picked up the turkey. They're thinking about travel plans. And if it was a misdemeanor trial or something, I would say, okay, maybe. But what if this trial drags on and they're splitting it between Christmas Day and New Year's? Where I can just picture any number of things going on, not to mention what's going on inside the minds of the jurors. What do you think of this?
I mean, that's absolutely tough, Aaron, because jurors, as it is, generally, they can think of all the other things they have going on that they'd rather be doing than sitting in a courtroom listening to witnesses. Now you have the holiday times, and who knows? They may have be like me, and they haven't done their Christmas shopping, and they're like, where am I going to find the gifts for, my family members and friends? It's really tough this time of year to get jurors to lock in and focus on the case when so much other things are going on. They probably wanted to go somewhere with their family. It's a tough one to try a murder case right now.
I could ask another question and we'd be speculating again, but are jurors more apt to be sympathetic this time of year than other times of year? I don't know the answer to that, but I would, maybe it is a good idea to try this case if you're the defendant this time of year.
Right. Hey, tis the season is what I've been telling prosecutors lately, and maybe that's what the defense is doing with the jurors, is trying to make sure that they remember the Christmas spirit.
Well, we will keep an eye on it. Again, the jury is being selected as we speak. That process has taken a little bit longer than everybody thought, as it oftentimes does. We're hoping to have opening statements tomorrow. So in the meantime, Andell Brown, criminal defense attorney, Miami, Florida. Always great to see you here on Law and Crime.
Great being with you, Aaron.
Okay, we'll catch up with you again soon.